In today's video, I will be discussing hotel liability for guest property from common law through today. In the past, rather than being written down into a comprehensive code, English law was the accumulation of legal customs and traditions, and it's been administered by the common law courts of England since the Middle Ages. Through the English common law, rules were also established for innkeepers. This is because the conditions of travel in the Middle Ages caused the innkeeper to play an important role in society. Roads were poorly constructed and often treacherous, and there was significant danger to the traveler from numerous outlaws that infested the forest they traveled through. And while it was possible to find protection in numbers during the daytime, the traveler was forced to find a house which would offer him protection as well as lodging for the night. Because of these dangers, one of the first duties imposed upon innkeepers was the duty to protect property of the guest, and under the English common law, an innkeeper was deemed responsible for the full value of any property of a guest or visitor. Today, the foundation of this rule is still in place in many states. However, there have been modifications, some of which take some liability away from the hotel. Some modifications that have been made are: in 1909, the Washington State Supreme Court approved 3 exceptions to an innkeeper's common law liability of an insurer. The court ruled that an innkeeper is the insurer of the property of his guests and liable for its loss from any cause, unless such loss comes from an act of God, the public enemy, or from the neglect of the guest himself. RCW 19.48.030 applies to guests' money, banknotes, jewelry, ornaments, negotiable securities, or other valuable papers or properties of small compass. The statute provides a safe harbor that eliminates liability to guests for loss of these valuables. To qualify, the hotel must first provide a safe for guests and then post a notice of the availability of a safe in 3 or more public areas like the lobby, elevators, and more. If the guest doesn't deposit their valuables in the safe after the notices, then the hotel is not liable for any loss of the valuables for any reason. Also, RCW 19.48.070 provides protection from liability for property losses of all kinds. It states that a hotel is not liable for any guest property loss unless the loss is occasioned by the gross negligence of the hotel or its agents. It also limits the hotel's liability to $200 unless the hotel enters into a written contract for more liability. It also has some important additional liability limitations that states that if a guest deposits the valuables with the hotel, then the hotel A is not liable for the deposited valuables unless the loss is caused by the theft or gross negligence of the hotel or its agents, and B, the liability is capped at $1,000. If a person at the hotel is not a registered guest, then liability for his property is further limited to $50 for a trunk, $10 for a suitcase, $5 for a box bundle or package, and $10 for wearing apparel and miscellaneous effects. If the guest pays more than 50 cents per day for lodging, then the liability for his property is limited to $100 for a trunk, $50 for a suitcase, $10 for a box bundle or package, and $50 for wearing apparel and miscellaneous effects. If a person sends property to the hotel without becoming a guest or leaves property at the hotel after the guest checks out and the relation between the guest and hotel has ceased, then the liability for the property is limited to $100. It also provides that when belongings are left with the hotel for at least 6 months, then, upon written notice to the guest, the hotel may sell the property at public auction to pay for any unsettled account or storage fees incurred by the hotel. But the hotel must be certain it has no written agreement to hold property for a period of time, and that a minimum of 6 months has elapsed. An example of a case implementing some of these changes in the present day is the case of Walls versus Cosmopolitan Hotels, where it confirms this safe harbor. The guest left a wristwatch valued at $3,685 on a nightstand and left his room, but returned to find the door to his hotel room damaged. Although locked, the door had been easily compromised and his room was entered, and the wristwatch had been stolen. The guest suspected negligence due to the ease of the entry and the lack of proper hotel maintenance because of the conditions of the door and lock, but the hotel's attorney argued that RCW 19.48.030 disposed of all the issues. The court agreed, finding that the wristwatch constituted valuable property of small compass and was therefore subject to statutory provisions. The court ultimately found in favor of the hotel and relieved the hotel of all liability regardless of the cause of the loss because the hotel property strictly complied with the statute and the guest had elected not to deposit his valuables into the safe they had provided. My final verdict is that changes in the law have had a positive impact. This is because situations have changed since the Middle Ages. Roads are better constructed and cared for today. Also, unlike in the past, not as much protection is needed at night, as there is little to no threat of being robbed or killed by outlaws, at least not while driving on a road at night. Due to these changes, there is no need for hotels to hold as much liability as in the past, and now the changes hold both parties, the guest and hotel, accountable instead of just hotels. This makes things fairer for the hotel as the ruling previously was strictly in favor of the guests, and unfortunately this often overlooked possible situations where the guests could have taken advantage of the ruling being in their favor.